Hi, I'm Hovik Oganesen from Ness Law, and I'm here to answer the most commonly Googled questions regarding premises liability. What types of accidents fall under premises liability? So premises liability, in short, is any injury that occurs while you're on someone else's property. And that could be public property, and it could even be private property. Public property, most commonly, sidewalks, public parks, anything that's maintained by the city or county falls under public property. Private property could include personal residence. If you're visiting a friend and you're injured on their property, that's premises liability. Also, most commonly, as a shopper within stores, any slip and falls, trip and falls while you're shopping, those are also considered premises liability. Who is responsible for your injuries in a premises liability case? It really depends on if your injury occurred on private versus public property. If your injury occurred on public property, it's going to be the governmental entity that owns, occupies, controls, maintains, or inspects the property on which you fell on. And on the private side, it's any owner or occupier of the property that's also in charge of maintaining, inspecting, or repairing the property. They, as landlords or even as governmental entities, are responsible to inspect and to ensure that their property is safe and hazard-free. And any failure to do so would result in them being liable for your injuries. How do you prove negligence in a premises liability case? In order to prove negligence in a premises liability case, you would have to show that the property owner knew or should have known about the dangerous condition which led to your injuries. That's actual versus constructive notice. Actual notice is being able to show that the landlord knew about it and did absolutely nothing to rectify the dangerous condition. Constructive notice is you're able to show, or you'll be required to show, that the landlord knew or should have known about the dangerous condition. The most common example of constructive notice occurs in grocery stores, where let's say there is a spill in one of the aisles and it's there for a prolonged period of time. Case law has held, anything over 20-25 minutes is a sufficient amount of time to impute constructive notice on the property owner. It basically follows the law that as property owners, there's a duty incumbent on you to inspect your property regularly. And had they done that, they would have noticed the dangerous condition and would have cleaned it up prior to someone falling. What kind of damages are typically covered in a premises liability lawsuit? So premises liability is just a form of personal injury. So whatever damages you're entitled to any personal injury case would be the same for a premises liability case. So that includes any past or future medical expenses, any lost wages or future loss of income, and most importantly, the general damages, which is the pain, suffering, emotional distress. You're entitled to all those damages in any premises liability case. If you fall on a broken sidewalk, can you sue the city? The answer is yes, for the most part. Property lines obviously play a major role in any premises liability case, obviously because the property owner ultimately is going to be responsible for your injuries. Most of the time, the public sidewalks are maintained by the city and therefore they will be responsible. I have seen situations where the actual location of where the injury occurred on the sidewalk was controlled by multiple defendants, including the private residence that was completely adjacent to the location of where the incident occurred. So the answer is yes, but you may be able to hold multiple defendants besides the city liable for your injuries occurring on the sidewalk. If the insurance company for the property owner is offering you a settlement in exchange for you not to sue their client in litigation, should you accept it? The answer to that question, it depends. If what they're offering you is fair and just compensation for your injuries, then absolutely you should accept it. Accepting a good pre-lit offer goes a long way and is far more beneficial to clients than accepting a slightly better offer throughout the course of litigation, because with increased costs, it pretty much comes out to about be the same thing. On the flip side, if what they're offering you is inadequate or low given your injuries, then you absolutely should not accept it. With premises liability cases, in any settlement, the insurance company is going to force you to sign a release. And a release basically is an exchange of your rights against their client or their insured for X amount of dollars. So once you sign a release, your case is barred from any future litigation. That being said, if you're ever presented with any settlement offer from any insurance company without having representation, I highly recommend you consult with an attorney as soon as possible to ensure that what they're offering you is fair compensation for your injuries. How much does it cost to consult with a premises liability attorney? The answer to that question is it costs absolutely nothing. In my office, we offer a free consultation for any and all premises liability cases. We will discuss the strengths and weaknesses for you. We will review any medical records you might have, and we will provide you with a detailed outline of where your case will go, all for free.